Now, the Constitutional Court is expected to deliver judgment on whether men can assume their wives' surnames. Now, the decision will be based on whether Section 26, subsection 1A to C of the Births and Deaths Registration Act is unconstitutional insofar as it unfairly discriminates on the basis of gender by failing to afford men the right to assume the surname after the woman after marriage. And again, let's talk to Canny Maphanga, who's on this story for us. Canny, again, a landmark ruling that is expected. And you spoke earlier about, some of the merits of this particular case that will be canvassed. And of course, what more can we say about this matter?
Indeed. Good morning to you, Sakina, and to the viewers at home. Once again, the Constitutional Court could possibly deliver yet another progressive judgment that could, if successful, place women and men in an equal legal position in marriages. Of course, what you can expect today for the viewers that are just joining us is that the Constitutional Court will be giving judgment on the application for confirmation of a declaration of constitutional invalidity against sections 26, subsection 1A to C of the Births and Deaths Registration Act. Two couples challenged this particular legislation in the Free State Division of the High Court, and they successfully did so. They did so because this particular section does not allow men to assume the surnames of their wives in marriage. It prohibits them from doing so. However, it does allow women to assume the surname of their male spouse. We saw the couples argue that infringes on the constitutional rights of equality and dignity, and it does so without justification and without a legitimate government purpose. They were successful in convincing the Free State Division of the High Court that there is no use to this legislation in the constitutional democracy that we enjoy today. However, for that declaration of invalidity to take place, they have to come to the Constitutional Court, which they have done, and it needs to be confirmed or not by the Constitutional Court. So this morning, the Constitutional Court will give their judgment as to whether the Free State Division of the High Court was correct in their assessment of the invalidity of the particular section. And in short, Sakina, what it means if these couples are successful, it means that this not only extends to Jana Joran and Henry van der Merwe, who wanted to assume the surname of Jana Joran as their family name, or for the Jess Donnelly Boardman and her husband, Mr. Boardman, who wanted to hyphenate his wife's surname and add it to his surname so that could be their family name of Donnelly Boardman. It means that it will extend to all who want to exercise their right to choose to take on their wife's surname or not. So these are the grounds upon which the Con Court will be giving their judgment today. Of course, if it is successful for these applicants, it will be yet another progressive judgment for these particular applicants and society at large, because it means that it will no longer be assumed that the male spouse's surname is a surname that will be carrying on the family name, but rather that a woman now can also take on her surname and give it to her male spouse and carry on the family name, meaning that it puts them on equal footing. So we expect at 9 a.m. this morning that judgment will be delivered, and of course we'll be giving you that judgment live when it begins. Over to you in studio.